Good day. Today we are going to talk about crimes against the fundamental laws of the state. They are called crimes against the fundamental laws of the state because they violate certain provisions of the Constitution, which is Article 3, and that is the Bill of Rights. So here are the lists of the crimes against the fundamental laws of the state. Arbitrary detention, delay in the delivery of detained person to the proper judicial authorities, delaying release, expulsion, violation of domicile, search warrants maliciously obtained and abuse in the service of those legally obtained, searching domicile without witnesses, prohibition, interruption, and dissolution of peaceful meetings, interruption of religious worship, and offending the religious worship. Okay, so let's go now to Article 124, which is a bar favorite or favorite bar topic. And Article 124 talks about arbitrary detention. And what are its elements? Number one is the offender is a public officer or employee, and he detains a person, and the detention is without legal grounds. So again, since this is a bar favorite, expect a lot of bar questions coming from this article. Let's start with 1975 bar examinations number 19. Answerable only by the provision itself. How is arbitrary detention committed, and what are the legal grounds for detention? So the answer is arbitrary detention is committed by a public officer who deprives another of his liberty without legal grounds. And the legal grounds for detention are commission of a crime, violent insanity, and any illness requiring compulsory confinement. Okay, so there's another bar examination question, 1980, number 11. Patrolman Cruz, who was acting under orders of the municipal mayor who wanted to put a stop to the frequent occurrence of robbery in Sitio Masukal, patrolled the place. At about midnight, seeing three persons acting suspiciously in front of an uninhabited house and entering the same, he arrested them without warrant and took them to the municipal building, where they were detained in jail for about 5 hours before they were released. Patrolman Cruz was accused of arbitrary detention. If you were the judge, would you convict him of the crime charged? Answer: Patrolman Cruz cannot be accused of arbitrary detention. Since the three persons acted suspiciously in front of an uninhabited house at midnight and entered the same, the policeman was justified to arrest them even without a warrant considering the circumstances of the case. Mainly, since he was patrolling the place upon orders of the mayor to put a stop to frequent occurrences of robberies therein. The three persons were arrested in a suspicious place at midnight and under suspicious circumstances that they were about to commit a crime or breach of peace. Good people do not ordinarily lurk in uninhabited places at midnight. This was the case of U.S. versus Santos, a very old case. Again, there is another bar question, 1992, number 12. Major Minor, while patrolling Bago-Bago community in a police car with SPO3 Kaloy at Leong, he blew his whistle to stop a Nissan Sentra car which wrongly entered a one-way street. After demanding from Linda Lua, the driver, her driver's license, Minor asked her to follow them to the police precinct. Upon arriving there, he gave instructions to Itleong to guard Lua in one of the rooms and not to let her out of sight until he returns, then got the car key from Lua. In the meantime, the latter was not allowed to make any phone calls but was given food and access to a bathroom. When Minor showed up after 2 days, he brought Lua to a private house and told her that he would only release her and return the car if she made arrangements for the delivery of 500,000 in a doctor's bag at a certain place within the next 24 hours. When Minor went to the designated spot to pick up the bag of money, he suddenly found himself surrounded by several armed civilians who introduced themselves as NBI agents. What criminal offense has Minor committed? Explain. Answer: Minor is liable under Article 124, which is arbitrary detention. He, being a public officer who detained a person without legal grounds. Violation of a traffic ordinance by entering a one-way street is not a valid reason to arrest and detain the driver. Such only merits the issuance of a traffic violation ticket. Hence, when Lua was ordered to follow the police officers to the precinct, that is, confiscating her license to compel her to do so, and confining her in a room for 2 days and prohibiting her to make phone calls, is a clear case of deprivation of personal liberty. Giving her food and access to the bathroom will not extinguish or mitigate the criminal liability. Minor is further liable for robbery because money or personal property was taken with intent to gain and with intimidation. The peculiar situation of Lua practically forced her to submit to the monetary demands of the major. In 2006, there was also a bar examination question concerning the arbitrary detention, but again, this is also answerable by the provision itself. So, what are the 3 ways of committing arbitrary detention? Explain each. So, the 3 ways of committing arbitrary detention are found in Article 124, Article 125, and Article 126. So letter A is by detaining or locking up a person without any legal ground or cause, therefore purposely to restrain his liberty. And Article 125 is by delaying delivery to the proper judicial authority of a person lawfully arrested without a warrant. And the last way of committing it is Article 126, which is delaying release of a prisoner whose release has been ordered by competent authority. Take note that in all the above stated ways, the principal offender should be a public officer acting under color of his authority. And another question is, what are the legal grounds for detention? Again, this was asked in 1975, and the legal grounds for detention are commission of a crime, violent insanity, or other ailment requiring compulsory confinement in an institution established for such purpose. Okay, so let's go now to another way of committing arbitrary detention, which is Article 125, delay in the delivery of detained persons to the proper judicial authorities. Its elements are: number 1, offender is a public officer or employee. He has detained the person for some legal ground. So take note, if in Article 124 there is no legal ground, here there is a legal ground. And number 3, he fails to deliver such person to the proper judicial authorities within 12, 18, and 36 hours. 12 hours is for offenses punishable by light penalties, 18 hours is for offenses punishable by correctional penalties, and 36 hours for crimes punishable by capital penalties or afflictive penalties. So here is a 1990 bar examination, number 11A. Amy was apprehended and arrested by Patrolman Bart for illegal parking. She was detained at the police precinct, underwent investigation, and released only after 48 hours. Is Patrolman Bar liable for any offense? Explain your answer. Answer is Patrolman Bart is liable for violation of Article 126 of the Revised Penal Code, that is, delay on the delivery of the detained person to the proper judicial authorities. So let's go now to Article 126, that is delaying release. Again, this is another form of arbitrary detention. What are its elements? Number 1 is offender is a public officer or employee. Number 2 is there is a judicial executive or an executive order for the release of a prisoner or detention prisoner, or that there is a proceeding upon a petition for the liberation of such person, and that the offender, without good reason, delays. Number 1, the service of the notice of such order to the prisoner, the performance of such judicial or executive order, or the release of the prisoner, or the proceeding upon a petition for the release of such person. So take note of without good reason And take note of these three ways of committing delaying release, and that is delaying the performance of a judicial or executive order for the release of a prisoner, unduly delaying the service of the notice of such order to said prisoner, and number three is unduly delaying the proceedings upon any petition for the liberation of such person. Let's go now to Article 127, which is expulsion. Elements, again, offender is a public officer or employee, and he expels any person from the Philippines or compels a person to change his residence, and the offender is not authorized to do so by law. So there are two ways of committing expulsion, and that is, number one is you expel a person from the Philippines, and number two is to compel a person to change his residence. Here is an MCQ 2012 bar examination question number 34. What is the criminal liability, if any, of a mayor who, without being authorized by law, compels prostitutes residing in his city to go to and live in another place against their will? Number one is the mayor is criminally liable for violation of domicile. Number two is the mayor is criminally liable for expulsion. Number three, the mayor is criminally liable for grave coercion. And letter D, the mayor incurs no criminal liability because he merely wants to protect the youth against the indecency of the prostitutes. The answer is letter B, the mayor is criminally liable for expulsion. Okay, so let's go to Article 128, which is violation of domicile. I want you to to study this carefully, to study this article carefully, just like 124, because again, this is a bar favorite. So what are the elements? Again, offender is a public officer or employee, and that public officer or employee is not authorized by judicial order to enter the dwelling and or to make a search therein for papers or other effects. And there are three ways of committing violation of domicile, and that is, first, you enter the dwelling against the will of the owner. You search papers or other effects found therein without the previous consent of the owner. And last is to refuse to leave the premises after having surreptitiously entered said dwelling and after having been required to leave the same. Here is a lengthy bar examination question which was asked in 1989. So let's call them A, B, and C. A, B, and C were looking for a person named Virgilio whom Carlos suspected of stealing his fighting cock. A and B were policemen, while C was a caretaker of fighting cocks. Carlos, or C, requested A and B, then in uniform, to accompany him to Virgilio's house to look for the fighting cock. A, B, and C went to Virgilio's house. When the policeman knocked on the door, Virgilio's wife, Maria, opened it. The policeman told Maria that they came to inquire about a lost fighting cock. Before Maria could utter a word, the trio barged inside the house. Once inside, the policeman told Maria that C was suspecting her husband, Virgilio, to have stolen his fighting cock. Maria protested and immediately required the three to leave. The policemen refused. Instead, they started searching the house for the fighting cock over the objections of Maria, who said that she would file a complaint against them after her husband comes from work. As they did not see any fighting cock, the three left. What crimes, if any, did A, B, and C commit? Okay, so the answer is A and B, being policemen, committed the crime of violation of domicile. There are three ways by which a public officer or employee may commit this crime, and that is, number one, you enter the dwelling against the will of the owner. In this case, the door having been opened by Maria, although A, B, and C barged inside the house before Maria could utter a word, they did not enter against Maria's will, there being no opposition or prohibition against entrance, whether express or implied. without the consent is not against the will. Number 2, or the second way of committing this Article 128 is you search the papers or effects found therein without the previous consent of such owner. Maria had objected to the search for the fighting cock inside her dwelling, but despite said objection, the policeman searched the house. This makes them criminally liable for the second way of committing the crime of violating of domicile. And number 3 is by refusing to leave the premises after having surreptitiously entered said dwelling and after having been required to leave the same. Although the policemen were ordered to leave the house, they did not enter it surreptitiously, which means clandestinely or secretly. And so far as C is concerned, he, not being a public officer or employee, he cannot commit the crime of violation of domicile. He is also not guilty of trespass to dwelling, either because he did not enter the dwelling against the will of the owner, which is the essential element of trespass. There is this 2002 bar examination question, a comparison. What is the difference between violation of domicile and trespass to dwelling? First, the offender in violation of domicile is a public officer acting under color of authority, whereas in trespass to dwelling, the offender is a private person, or he may be also a public officer but acting in a private capacity. And in violation of domicile, it is committed in 3 different ways. We already discussed it. And while trespass to dwelling is committed only in one way, and that is you enter the dwelling of another against the express or implied will of the latter. In 2009, there was this bar examination question, which was a true or false. A policeman who, without a judicial order, enters a private house over the owner's opposition is guilty of trespass to dwelling. Is it true or false? Answer: false. The crime committed by the policeman in this case is violation of domicile because the official duties of a policeman carry with it an authority to make searches and seizure upon judicial order. He is therefore acting under color of his official authority. Article 129 is search warrants maliciously obtained and abused in the service of those legally obtained. So there are 2 ways of committing it, and first is by procuring a search warrant without just cause. The elements are: number 1, offender is a public officer or employee. He procures a search warrant and there is no just cause. The second way of committing it is by exceeding his authority or by using unnecessary severity and executing a search warrant legally procured. Again, the elements are: offender is a public officer or employee. He has legally procured a search warrant and he exceeds his authority or uses unnecessary severity in executing the same. Okay, so here is in old bar examination question related to Article 129. The question is, under Article 129 of the RPC, any public officer who shall procure a search warrant without just cause shall be punished by fine and imprisonment. What do you understand by just cause? Answer of the UP Law Center: just cause means such reason supported by facts and circumstances as will warrant a cautious man in the belief that his action and the means taken in presenting it is legally just and proper. So we will go now to Article 130, which is searching domicile without witnesses. Elements are the following. Number 1, again, offender is a public officer or employee. He is armed with search warrant which was legally procured, and he searches the domicile, the papers or other belongings of any person, and the owner or any members of his family or 2 witnesses residing in the same locality are not present. Article 131 is about PID, or the prohibition, interruption, and dissolution of peaceful meetings, and there are 3 ways to commit it. And number 1 is by prohibiting or by interrupting without legal ground the holding of a peaceful meeting or by dissolving the same. Number 2 is by hindering any person from joining any unlawful association or from attending any of its meetings. And number 3 is by prohibiting or hindering any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses or redress of grievances. Okay, so Article 132 is interruption of religious worship. Number 1 element is offender is a public officer or employee. Number 2 is religious ceremonies or manifestations of any religion are about to take place or are going on. And number 3 is offender prevents or disturbs the same. Okay, so we are down to the last article, which is Article 133, and that is the offending the religious feelings. What are its elements? Number 1 is the acts complained of were performed, letter A, in a place devoted to religious worship, or letter B, during the celebration of any religious ceremony. And number 2 is the acts must be notoriously offensive to the feelings of the faithful. You have to take note of Article 133 because lately this has been a bar favorite because of that Mr. Carlos Saldran case. And also another thing to take note of this article is that this is committed by any person. So this article is committed not only by a public officer but also by a private individual. So that's it. I will see you in the next video. Thank you.